CV130282. ML et al. Versus Coles. For the party's information, we have read the briefs, reviewed relevant portions of the record, and conferenced the case this morning. Each side will have 20 minutes to discuss their the case. Appellants, you will have a you may reserve a portion of your time for rebuttal if you'll tell us when you arrive to the podium how much time you would like to reserve. We'll try not to horn in on your time. We understand that a settlement has been reached between the appellants and one of the appellees, Francine Coles. We will try to keep our arguments limited to Ashley Coles issues. As you arrive at the podium, you'll see that there's a time clock for each of you. You'll have 20 minutes to complete your oral arguments. And as you approach the podium, please say your name and who you are representing. The proceedings are being audio and visually recorded. Hopefully, if the machines are working right, you will be able to see yourselves on YouTube in a couple weeks. Or 20 minutes of fame. So, with that in mind, you may begin.
Good morning, Your Honor. Jim Holland here on behalf of ML Servicing and the ML Trust to pursue this claim. I'm obviously prepared to address all the issues and have statements, but before I do that, I'd like to know if there's anything that you would like me to focus on. I'd certainly like to tailor it accordingly.
No, he didn't start your time clock. I'm sorry. Go ahead.
Argue it as you deem it appropriate, and then we will not hesitate to jump in if there's something we want to ask you.
I have no doubt of that, Your Honor. I guess it starts with just the basic premise that ML is coming here pursuing a constructive trust, which is something that is different than was ever contemplated by the exemption statute that has been raised as a defense here. Constructive trust will arise as our Supreme Court has already declared in King v. Ullman. Constructive trust will arise whenever the circumstances make it inequitable that the property should be retained by the one who holds legal title. The forms and varieties of these trusts are practically without limit, and the principle is applied whenever it is necessary for the obtaining of complete justice. Now, there's basically two things that are necessary for constructive trust. One is a wrongful taking of property. The other is the ability to trace the funds directly. That is, we're not just a general creditor. Well, in this case, the wrongful actions include a wrongful distribution from the corporate assets, conversion, fraudulent transfer, breach of fiduciary duties, and the corporate trust doctrine, to name just a few. In addition, as to the tracing, although that hasn't really been a subject of briefing or wasn't the basis of the appeal, we actually are able to show that money on a single day, large chunks of money, went from Mortgages Limited directly into Scott Coles Trust, and Scott Coles Trust directly to pay premiums for the policies. So this traces directly through. We're able to watch how tens of thousands and hundreds of thousands of dollars ultimately end up being diverted over for the purposes of purchasing these life insurance policies. So
I have a question for you.
Sure.
You've tracked this money. You can see these payments coming out of ML Trust's accounts into Scott Coles accounts. Can you address for us, was there some point at which the trust authorized this to occur? Is there a circumstance by which Coles might argue, if he were here, authority to have taken it or an agreement of the parties to take it?
Well, actually, let me be clear about something. When we're talking about trust, the Scott Coles Trust I'm talking about is his personal trust. That is his personal. So the wrongful taking had already occurred between Mortgages Limited and that trust. And while Mr. Coles was in fact running the company was badly insolvent. And so under principles of statute and common law, he wasn't allowed to continue taking the money, and certainly not at the rate he was taking it. And so whether or not he agreed with himself that he was going to take the money for the company, the fact of the matter is the statutes prohibit it. It was a wrongful distribution under the corporate law. It was a conversion. It was a breach of his fiduciary duties. And under the common law corporate trust doctrines, he wasn't allowed to take that money. And so that is what establishes the right for us then to trace this money into the insurance policies. Did that answer the question? So the trust, as we talk about it when we talk about the ML trust, that's the bankruptcy trust. All that that's saying is that we're standing in Mortgage Limited shoes.
And Mortgage Limited is what I meant to refer to. Mortgage Limited, as I understand it, according to your complaint, says we had a meeting, right? We sat down with Coles. We agreed that he could create keyman policies.
Keyman policies are not at issue in this case. In fact, we've abandoned those claims. That's not the issue before here, right now. What's at issue is the fact of the matter is that as soon as Mortgages Limited became insolvent, which happened months and years before this money was withdrawn, when it was insolvent, in fact, the truth of the matter is that Mr. Coles was even advised by his attorney that what he was doing was criminal when he continued to be raising these funds and when he continued to be distributing and when he continued to draw on these funds. And so there wasn't a meeting that he could do. No meeting between himself and his company was going to whitewash this. What he was doing was wrong.
So the issue is not that Mortgages Limited authorized the payment of insurance premiums and that Coles misdirected those so that the beneficiaries were his personal family as opposed to the company itself, but rather that at the point in time the money left Mortgages Limited, the company was already insolvent.
That is correct. It was a deepening insolvency. And as a result of that insolvency, there was no ability to take that money. So the issue before then the court is whether or not, it's not so much whether or not we're entitled to a constructive trust. In fact, I might point out, neither Francine nor Ashley ever challenged the notion that we're entitled to a constructive trust. The issue that has been before the court is whether or not a constructive trust is going to be subject to exemption statutes. And the answer there is absolutely not. Constructive trusts are not subject to exemption statutes. That has already been spoken of by this court in the Harmon case. It spoke to it very pointedly and just simply said, one of the reasons why plaintiffs may pursue and want to pursue a claim for constructive trust instead of money damages is that you're able to pursue money that would otherwise be triggered by the exemption statute. The restatement is very clear on this point that constructive trust claims are not subject to exemption statutes. In fact, the restatement not only speaks of it directly, but then provides an illustration, two illustrations actually, directly on point, speaking of constructive trusts being able to obtain money that is otherwise named for other beneficiaries. And in one of those illustrations, the whole point was to show that it's not subject to exemption statutes. Then we get to really the real meat of this is the fact is that when Arizona legislature adopted this statute, they adopted the statutory language that had already been interpreted. That is, in Oregon, the Oregon Supreme Court, almost 20 years before Arizona adopted this statute, had construed its own statute. And Arizona copied that statute almost word for word. And therein, in the Jansen case, the Oregon Supreme Court, in no uncertain terms, laid out that, in fact, a constructive trust was proper and that the constructive trust was not subject to the exemption statute. The reason is because through a constructive trust, the plaintiff is not standing as a creditor. The plaintiff owns the property. That's the whole point. As we go back to the original point is that a constructive trust will arise whenever circumstances make it inequitable, and it will take title from the equitable title or the beneficial title from the party who holds legal title. It separates the title so that the beneficial interests lie with the plaintiff and only legal title and bare legal title only rely with the defendants. And so that was already decided by Jansen. That language precisely was already interpreted when our legislature adopted it. And the judicial interpretation I'm going to share with you a couple cases that in fact this court said in State v. Bookseller in 139 Arizona 525, judicial interpretation adds meaning to a statute as certainly as if the words were placed there by the legislature. Our Supreme Court said in Galloway v. Vanderpool at 205 Arizona 252, once published, an interpretation becomes part of the statute. Accordingly, if the court revises its statutory construction in a later decision, the departure from precedent arguably amounts to an amendment of the statute itself, rather than simply a change in the thinking of the judiciary with respect to common law principles, common law concepts with which courts are allowed to change. So this was already, that statutory language already came with it, embedded into it, the notion that constructive trusts, that owners could continue to pursue their property and were not morphed into becoming creditors, that they were going to be able to continue to pursue their property and the proceeds thereof, notwithstanding the exemption statute. So on top of that, the legislature, even if we lay aside the Oregon Supreme Court, which our own Supreme Court has said that when we adopt a statute that's already been interpreted, that language is, that decision is heavily persuasive, if not controlling. Laying aside that, our legislature is presumed to follow common law and to not repudiate common law unless it explicitly says so. In fact, the language is, according to this court, has said in Terry v. Linscott, that it must be clearly indicated. That's the magic language. If it doesn't clearly indicate an intent to repudiate common law, then the statute must be construed as being consistent with common law and allowing common law remedies. It also, the same principle was stated by this court in a State v. Felon, where clear manifestation of intent is required to supersede common law. And the court then went on to say the court must indulge every intendiment in favor of consistency with the common law. There is plenty in this statute where the legislature was clearly indicating, doesn't even need to clearly indicate, it could be a tie base. We still end up with the court should default to common law principles, but the legislature actually talked about lawful beneficiaries, and it only limited the exemption to creditors. And there's something significant about that, because if you look at many of the other exemption statutes, the others in Title 33, the court or the legislature doesn't limit it to just creditors. They in fact say there's no process allowed, no garnishment, no attachment, no execution is allowed when they're talking about others. Here they only say creditors can't pursue those claims. And if the court is going to read in order to say that creditors can mean that owners can't come in, then the court's reading that language out of existence. The fact is that the legislature was meaning something different. Now, on top of that, the statute is presumed to not repudiate equity. The legislature doesn't defeat equity unless it specifically says so. In fact, this is what our Supreme Court said about this issue in Valley Drive-In Theater. Valley Drive-In Theater, by the way, was cited by Ashley Coles in her brief, says the final object of equity is to do right and justice. Its principles, that is equitable principles, will be applied in the construction of a statute to the end that it may be liberally construed so its objects may be promoted and justice effected. But when the statute is perfectly clear and has determined the matter with all its circumstances, equity cannot intermeddle. So the real question is the statute perfectly clear that owners are not allowed to come in and make their claim? If the court is to utilize that analysis to say that owners cannot make their own claims, owners cannot come in and recover, then there are other situations in which we must ask. One of the exemption statutes actually says that up to $300 in a bank account is exempt from execution or attachment. Now, if my wife is walking down the street and a purse snatcher comes by and grabs that purse and sprints for Bank of America, she on his heels running after him trying to get her money back, and he grabs that $300 and throws it into the bank account and says, it's in there, I am now exempt. Owners can't come in and claim this, according to the argument that Ashley is making. Owners can't come in and claim their own property. I've got an exemption. My $300 is now protected. Owners can't come in according to the exemption. That's what the court is being asked to construe the statute as. By the same token, if your neighbor borrows your car because they have a flat tire, there's an exemption that allows them to retain a car up to $6,000 in value. If the neighbor refuses to return that car, I am, quote unquote, I guess, a creditor. I'm allowed to sue them, but I'm also entitled to replevin. I'm allowed to get my property back. And if in fact that car has gone up in value, I'm allowed that also. If it turns out that it's a rare vehicle or all of a sudden there was something discovered about it that was unique. The point is that exemptions do not prevent owners from getting their own property back. And that's really what this case is all about, is preserving the right for owners to be able to obtain their own property. Now, the other issue that's buried into this is the fact that property includes the proceeds of property. That is well established in Arizona case law. It's established really by some of the statutory, and it's certainly throughout the restatement. It includes proceeds, not just a recouping of the money that was taken, but in fact, all of the benefits that would be had. Otherwise, the court and the legislature would have been establishing a basis behind which people are encouraged to do bad acts because they're going to benefit from doing the bad acts. And so in order to allow for the disgorgement of ill-gotten gains, owners are entitled to the proceeds entirely. I'd like to reserve the remainder of my time unless there's something that the court, if you have other questions, I'd like to address them now.
Nope, I think we're good. Thank you.
Good morning, Your Honors. Todd Feltus on behalf of the appellee, Ashley Coles. And may it please the court, the trial court correctly granted the motion to dismiss, and the judgment in this case should be affirmed. Mortgages Limited complaint is premised on claims that they had against Scott Coles. It's premised on being a creditor of Scott Coles.
Are they not able to be both a creditor and not a creditor? I mean, is there any requirement that you've got to pick one over the other? In other words, I guess I'm trying to think of an analogy. You get hit by a DUI driver. Does that mean that the DUI driver can't be prosecuted because you sue him civilly, or does that mean that you see what I'm saying? Is there anything that says that ML can't come in as something other than a creditor?
I think, Your Honor, respectfully, I think it's based on a false premise, because if ML is not a creditor, they don't have a civil claim. I mean, we're here to compensate wrongdoing. So in your DUI example, the person who is hit by the drunk driver is a creditor of the drunk driver. It's a contingent claim that they have against them for whatever harm that they suffered. I mean, creditor is just someone who owes someone else money, and the premise of ML's complaint's really twofold. I mean, I guess they've now abandoned the claim that there is a breach of a promise to buy Keyman insurance, but the other basis of their claim is that there apparently now is that, though I'm not sure it was argued below, at least in Ashley's case, but the premise is that there was a wrongful distribution. So they're saying that Scott owes money to Mortgages Limited, that they're a creditor. So I guess I don't understand how someone could not be a creditor and not have a civil claim. You're either owed money or you're not. And that's the dictionary definition of a creditor. I think that's the Speedway case from the Georgia Court of Appeals from 2 years ago has a nice discussion laying out. I mean, they go through a notion of voluntary or an involuntary creditor. But I think the premise is pretty simple. I mean, just go to the dictionary. I mean, creditor is someone who owes someone else money, period. And the claims here, there's no allegation of wrongdoing against Ashley. The claims are Scott Coles took money that he shouldn't have taken. He owes money to Mortgages Limited.
And I guess their argument is that because he wrongly took money, that they are entitled to a constructive trust. It's not, and I think that whether Ashley did anything wrong or not, the fact of the matter is that Scott fraudulently took money from ML and paid these life insurance proceeds. And the restatement seems pretty clear that under those conditions, you can you're entitled to a constructive trust to collect not just the premiums, but also the proceeds of those funds.
Okay, there's a lot to unpack there, and let's start with the restatement provision. I agree with you. The restatement says exactly that. Arizona courts don't, while we generally follow the restatement, we don't blindly follow the restatement. The restatement doesn't exist a lot of the contrary. And the Valley Drive-In case, 1955 Supreme Court case, says that a court of equity has to follow what the legislature's done. And the Valley Drive-In case had a very lengthy quote, goes over a half page long, from the Douglas case, 1917, that states, when a statute is perfectly clear and has determined the matter with all its circumstances, equity cannot intermeddle to supply a supposed deficiency of those things which are required. Now, the quote is contained within Valley Drive-In, and it's from the Douglas case, 1917. The restatement of restitution was 1937. So, it was already contrary to Arizona law. Arizona law, and it should be noted, a constructive trust is not a common law claim, it's an equitable claim. Mm-hmm. So the notion that statutes have to be specifically intended to overrule the common law doesn't come into play here for this claim in equity. But Arizona courts have consistently, from statehood, have said that a court of equity cannot intermeddle in the plain language of statute. They said it in 1917 in the Douglas case. They said it in 1955 in the Valley Drive-In case, where they said you can't get an injunction to stop a writ of replevin. The replevin statute trumps the equitable remedy of injunction. They said it again in 1971 in the Solt case. The Court of Appeals said that equitable considerations cannot trump statutory election law. Court of Appeals said it again I believe it's last November in the White's case, which we cited in our supplemental citation of authority, that equitable subrogation does not trump the mechanics lien statute. So to disregard literally a century of case law in this state, going right back to immediately after statehood, is the only way you can get there to apply a constructive trust to contradict the plain meaning of 20-1131. And the Arizona Supreme Court and the Court of Appeals, in construing 20-1131, have found that the statute is unambiguous. So we've got statute with plain meaning, and I think the only plain meaning you can get out of A is that a creditor is not entitled to the proceeds. B, I think, addresses the injustice that may be perceived that takes place, because it gives someone who's been deprived in the instance of mortgages limited, they'd have a right to the premiums, which is really what they were out, if we believe the allegations that are in the complaint, and which, they state tens and hundreds of thousands of dollars. The complaint says $130,000. But they didn't ask for the premiums. And that's what the statute gives them the right to. And equity can't come in and change the plain language of the statute. And to say, well, there's something magical about a constructive trust, I'm not sure that there's any support in the law on that. Constructive trust requires clear and convincing evidence, so courts in this state have concluded that it requires an elevated standard burden of proof to show. There's certainly nothing that's been cited in the briefs, and nothing that we could find that would elevate constructive trust as an equitable remedy above the equity of an injunction or equitable subrogation or some kind of equitable considerations that would overrule an election statute. So the constructive trust, it exists as an end run around the statute, and the meaning of the statute's pretty plain here, where creditors don't have a right against the beneficiary of life insurance policy under A. If there's been fraud of creditors, they can go after the premiums. So they're not out. They have the opportunity to be made whole. If we allow the end run of a constructive trust, which is always going to show up in the life insurance context, because the wrongdoer is no longer with us. They've left behind a pot of money that creditors can go chase. won't bring the claim directly, I guess, because the 11, and certainly ML hasn't done that because 1131A gets in the way. So what's to stop anyone from bringing a constructive trust in any context? I mean, it would completely undermine the whole purpose of 1131, which is to allow heirs to provide for, or I'm sorry, allow people to provide for their heirs. And the means that that's often done is in life insurance. And the cases have stated that this is often the most valuable asset that's being passed down by a decedent. And it would provide a pot of money for any creditor to be able to go after. And if the finding is, well, creditors don't have a claim except for a constructive trust, well, everyone out there that's going to be able to go after life insurance proceeds is just going to plead a constructive trust, and they'll be able to end run around the statute, and there will be none of the legislative protections that we're going to provide here for heirs and for beneficiaries of life insurance policies. Now, in making that policy determination, the legislature, there's competing interests here. And certainly in that Oregon case, they talk about, well, we don't want to allow wrongdoers to profit from their wrongdoing. And Jansen does have the discussion of that. They don't talk at all about the flip side of that in the life insurance context. What do we do with what do we do about the beneficiaries? And that discussion does take place in the Oronado case, which is a 1951 Louisiana case, which would have been 3 years before this statute was in place. That discussion takes place. The policy balance that has to take place is discussed in the Speedway case from Georgia. And the Georgia instance is pretty interesting because if you read through in the text in Speedway, their statute was virtually identical to the Oregon statute. And it references a case from the 1920s in Georgia where the Georgia court had said, where they had the exemption statute, and the Georgia court said, we're going to allow the exemption for all purposes. Georgia's legislature didn't like that, and in the 30s, about the same time as the Jansen case, they went in and revised their statute to put in a right to recover premiums similar to our 1131B. Now, the Oregon statute admittedly had the same thing there, but there wasn't any discussion in the Oregon case about what an Oregon court will do as a court of equity in overruling the plain language of statute. That Jansen case took no consideration on that, unlike Arizona's nearly century-long tradition of courts of equity not getting in the way of plain language of statute. And really the best discussion of that principle is in the Wilmington Trust case, which is a 1975 Delaware case. And Wilmington goes through, it discusses Jansen and discusses two other cases of that era. And why I think the Wilmington case is interesting is because in Delaware, they have a division between courts of law and courts of equity. And the Delaware court was sitting as a court of law, and it basically said, hey, we've got these three cases out here that kind of decided to roll their own solution in light of a statute with plain language. And what the Wilmington Trust Court said is, these are courts sitting as courts of equity. We are sitting as a court of law, and that decision's left to the legislature, and we do not have the power to usurp that. Now, why that's important is because, again, the Douglas, Valley Drive-In, Whites, that whole line of cases over that whole period of time have basically said in Arizona, courts of equity are almost more, when they're dealing with the plain language unambiguous statute, they're really in the same stance that the Wilmington Trust Court was, that the courts aren't going to step in and make the policy decisions that the legislature is tasked with making. And that's really what ML's trying to do here, is to have a judicial balancing of the public policy. And they're saying, well, you need to weigh the compensation of wrongdoing at the expense of the beneficiaries of life insurance policies. The legislature's made a different judgment call. And the legislature's entitled to make that judgment call. They were certainly free to say that someone in ML's position, if their claims are true, maybe we won't have an exemption there. That's certainly the policy decision the state of Texas made. And Interestingly enough, ML relies on a whole number of Texas cases. Well, Texas doesn't have the equivalent to B for premiums. They basically say if you can show fraud of creditors, there's no exemption. So, long-winded way of coming back to your Honor's question is that the constructive trust remedy can't usurp a statute in Arizona. Arizona is unique in that, certainly from the cases that are going back to the 1920s and 1930s. It's unique in that the policy Arizona courts have announced for nearly 100 years is that even a court of equity is not going to get in the way of the legislature. The laws to the contrary in Oregon, Kansas, and Wisconsin, I believe, were the three cases. So to the extent we're looking at cases outside.
But isn't really what they're trying to say is we're not a creditor. We own these policies because the money was wrongfully taken from us. And therefore, that's why we're not a creditor. Address that.
Sure. No, and that's a good question. That question was answered by the Court of Appeals 2 years ago in the state of King. There is no property right in the policy proceeds. And King really tracks with 1131B because reading the statute and King together, the property rights and the premiums. I mean,
So you're saying they have a dollar claim against somebody, but they don't have a right to the policies themselves?
Assuming everything in their complaint's true, they obviously have a claim against Scott Coles.
Okay.
I mean, if they haven't asserted that. If they can prove that there's been fraud of creditors, they'd have a claim for premiums against the policy beneficiaries from the policy proceeds, but they don't have a claim against the policy proceeds. And to say that the policy proceeds are their property, that goes contrary to what this court ruled 2 years ago, that there is no property right in the policy proceeds.
Close the door for me.
Sure.
Ashley or Francis, did they have any position with Mortgages Limited?
Not that I'm aware of.
So in regard to the issue of a misappropriation claim, they weren't writing the checks out of Mortgages Limited that drained the accounts for the purposes of buying these proceeds, these policies.
Yeah, no, I think that's absolutely correct. I mean, and that certainly was never alleged in any of the four. I mean, there's been two amended pleadings in both the cases against Ashley and Francine. So in the four pleadings, there's no such allegation to that effect. And I think to get Judge Jones your earlier question, I mean, at the time before Scott Coles' death, he was the president, as alleged in the first amended complaint, at least in our case, he was the president and CEO of Mortgages Limited. His trust was the sole shareholder. I mean, that's what they've alleged. So, I mean, to say that there's some kind of meeting amongst the stakeholders, he was the stakeholder.
Well, clear this up for me. I mean, it's my understanding, has been my understanding throughout, that the complaint alleges that that Mortgages Limited believed a certain thing, which was that they stood to be the beneficiary of certain keyman policies. That's just gone now. They no longer are alleged to have believed that they were the beneficiary of certain keyman policy proceeds?
That's, I mean, in our case below, and we kind of went on different tracks on the motion to dismiss, ML was asserting that they were an intended beneficiary. And they got through a first motion to dismiss, and the trial court didn't address 1131. So when we redid it and we pointed out in Arizona to be an intended beneficiary, you need to be in the insurance contract, and they weren't. They abandoned that claim at that point in time.
Thank you.
I guess one last point, and then I'll conclude on the Harmon case. And I'm even more confused in reading it the last few days, getting ready for this. There, the divorce case, the husband was trying to get property back from the wife. He didn't want a constructive trust. So, I mean, one, there's no discussion of exemptions. There's a footnote about why someone might want a constructive trust, but the husband successfully said, I don't want a constructive trust because I don't want to have to prove this by clear and convincing evidence. My wife owes me $100,000 for taking the property. I just want to do it the direct way. So, I mean, Harmon isn't this silver bullet that saves ML's claim. And really to get where ML wants to go and to reverse the decision of the trial court, the court would really need to do the following things. I mean, one, they'd need to create some unwritten exceptions into 20-1131 and say that, well, for this certain type of claim, or if someone asserts themselves as an owner, not a creditor, and there's no case law to assert that, well, then 1131 doesn't apply. The court would have to disregard the two cases that have construed 1131, May versus Ellis and the State of King, that have said that 1131 needs to be broadly construed.
But in neither of those cases, was there an argument that said, that where there was an allegation that the premiums were paid with money that was fraudulently obtained? So really, that issue hasn't been addressed, and at least as I read those cases, I don't see that they get you anywhere. They clearly state the statute is unambiguous, but the argument that that money obtained fraudulently by the insured to pay the premiums and money that belonged to somebody else was fraudulently obtained. Those issues were not really in either one of those cases, were they?
That issue, no, and I agree with that. It's and if I can finish answering the question as I'm out of time. What they do announce is the policy rationale that to protect beneficiaries of life insurance policy and the statutes to be construed broadly. The cases from the 20s and the 30s basically ignore that policy rationale that the legislature has made.
Okay. Thank you so much.
Thank you.
Let me first clear up something that I think I didn't do well enough the first time, and that is we affirmatively abandoned the key man policy issue at the trial court. The trial court doesn't ultimately address it in terms of its findings because we told the court we're abandoning that prior to even getting to a decision on that issue. So the court...
Was I wrong in reading that you had, wasn't there some discussion of it in your briefs, or was it in...
It would have been in someone else's briefs. It was not ours. This is all about constructive trust and ownership interests.
Okay. And why aren't you a creditor? I mean, if you look at the definition of a creditor, you seem to be somebody who's owed money. It was fraudulently taken from you, so why aren't you a creditor?
Well, first of all, it's, as you mentioned a little bit ago, it's possible to wear more than one hat. And yeah, we could be a creditor if we chose to sue that way. Harmon recognizes that. You can choose when you're owed certain property. You can choose to sue as a creditor. Harmon says that. Or you can choose to sue as a constructive trust. We don't deny that we could have been a creditor.
But if you're trying to get your property back, which is sort of what a constructive trust does, why isn't your property simply the money that was used to purchase the policies, the premium payments,
well, because
which is contemplated in the statute itself?
Well, actually, that's not contemplated in the statute itself. The constructive trust goes to all the proceeds. It goes to, if it was real estate that we had a constructive trust in, and there was gold discovered on that property, we own that gold. If it was a lottery ticket, we own the lottery winnings if it ends up being that way. The restatement is replete with that analysis. Actually, King v. Ullman, Arizona Supreme Court, explains that principle, and in fact, Harmon, this court, says that you get the benefits of it. Now, in terms of that...
Harmon is in a footnote, and it says, these are the reasons why you would want to have a constructive trust.
Correct.
Isn't it? I mean, it doesn't really say, I don't think it goes as far as you want it to go. I think it just says, in a footnote, these are the reasons why you would want to have a constructive trust. And it lays out 3 or 4 reasons why, and I think it does stand for the proposition that you can wear separate hats, but I'm not really sure that it goes as far as you.
It simply observes that it is established case law. It is citing to established principles of law. It cites Dobbs. Dobbs cites lots of other cases. It could have cited the restatement if it chose to, both the first and third. It could have cited all kinds of other stuff. But the fact of the matter is, and it could have cited, for that matter, a whole legion of other cases. The principle is simply one that the proceeds of the property go to the owner of the property. And when somebody improperly takes property, it doesn't matter, by the way, to answer, Your Honor, your question earlier, it doesn't matter whether or not the Coles were innocent. If a purse snatcher runs and grabs money and then hands it off to an innocent bystander, the innocent bystander can't say it's now my money just because I didn't do anything wrong.
But it would certainly be different if they were complicitous in the misappropriation as fiduciaries of the trust, right?
Well, it would certainly give us an independent cause of action against them in addition to anything else. If it was part of a conspiracy, if it was, yes, we would have an independent cause of action, then we might even be able to claim punitives, but that's not really what's at issue here.
Thank you.
What's at issue here is simply a question of ownership. And the fact of the matter is that Mr. Feltus cited to Valley Drive-In. And I want to refer back to Valley Drive-In. Valley Drive-In, he was citing it for the principle that the equity and the courts can't just ignore the legislature, that the statute, in fact, can supersede constructive trusts. We have never contested otherwise. We absolutely agree. If the legislature speaks to that point, the legislature absolutely can do away with the constructive trust remedy. Now, in doing away with the constructive trust remedy, Arizona case law, this court has already ruled that if you're going to do away with common law remedies such as constructive trust, it must be clearly indicated. That's the language this court has used. And
Is it a common law remedy? Because I think Mr. Feltus said it was a equitable remedy.
yes, it's a common law principle in equity. And that gets to the next point, and that is equity. As Mr. Feltus already cited to in Valley Drive-In Theater case, in order for the court, equity will continue to be read into a statute. And in fact, the Supreme Court said, we're going to struggle to try to preserve equitable principles in a statute as long as it's not completely barred. And the language that the Supreme Court says, it must be perfectly clear that, in fact, the legislature meant to do away with that claim. Well, the legislature was not perfectly clear that it wished to supersede constructive trust when it adopted a statute that had already been interpreted as allowing constructive trust. It was not perfectly clear that it wished to do away with constructive trust when it followed exactly the language that the restatement statutes had been following and all the statute case law that was there. It was not perfectly clear that it wished to do away with owners when it only talked about in a statute that creditors were barred from a claim. And it talked about lawful beneficiaries. It wasn't perfectly clear in those instances. And so equity is still read into the statute. It has not been abrogated by this statute. Now,
Your time is up.
oh, I'm sorry.
So it's okay. Okay. Thank you very much for your arguments. They were both very well done. Gave us more food for thought, and so thank you for that. We're going to recess briefly to allow the next argument to come forward, and
Take it under advisement.
Pardon?
Take it under advisement.
And we're going to take it under advisement
Thank
and
you.
issue a ruling in due course. Thank you.